Hello, everyone, and welcome to Uncivil Law. For today's case, we have a pending matter before the Court of Appeals for the D.C. Circuit. This is the Committee of the Judiciary in the House of Representatives versus Don McGahn. In this situation, we're learning about the subpoena for Don McGahn to participate in and appear as it relates to the impeachment hearings. As you may remember, the impeachment was voted on. And so one of the issues the court of its own initiative asked to be briefed on, because the oral arguments are now set for January 3rd, one of the issues the court asked to be briefed on was whether or not the subpoena was moot, because the subpoena was issued by the Judiciary Committee for testimony as it relates to the impeachment. The impeachment has been voted on, so maybe the matter is disposed of. Maybe this issue is moot. And so we're going to review two briefs on this issue. We're going to review a brief from the Department of Justice, and we're going to review a brief from the House itself, which indicates that it may not be over because additional articles of impeachment may come. We're going to have another impeachment vote, basically, is what the House is telling us. So that's super exciting. So let's get started with this. First, let's turn to the Department of Justice's filing. Pursuant to this court's December the 18th, 2019 order, the Department of Justice, on behalf of appellant Don McGahn, files a supplemental brief addressing the effects of the article of impeachment on the issues in this case, including whether the articles of impeachment render this case moot and whether expedited consideration remains necessary. In its complaint, the committee alleges that, wholly apart from the impeachment proceedings, McGahn's testimony would assist the committee in assessing the need for remedial legislation and to conduct oversight. Although the suit is not moot, the impeachment vote affects the extent to which the expedited consideration remains necessary. The committee opposed the department's request for a stay pending appeal because the delay from such a stay would impair the House's ongoing impeachment inquiry. In doing so, the committee stated that speedy judicial action is needed to avoid hampering the House's impeachment investigation, and that justification no longer applies. The articles of impeachment affect this case in two other ways. Before the impeachment vote, the committee had no response to the department's point that a court, as a matter of equitable discretion at a very least, should refrain from entangling itself in an inter-branch dispute when Congress as a whole has not made a conscious choice to clearly grant the court's subject matter jurisdiction over the committee suit and a committee cause of action to sue at all. The reason for refraining are even more compelling now that what the committee asserted, whether rightly or wrongly, as a primary justification for its decision to sue no longer exists. The articles of impeachment addressing the purported obstruction of Congress relies in part on judicial proceedings in this very case. The House Judiciary Committee impeachment report, for example, cites the district court's characterization of the Justice Department's litigation position in this case for the proposition that the president insists on unfounded doctrines, such as absolute immunity, precludes the testimony by many current and former officials who may shed light on presidential abuses. Pursuing an inter-branch suit in court while simultaneously pursuing impeachment and then using that litigation as part of the impeachment proceedings is far from the traditional model of common law's cause of action at the conceptual core of the case or controversy requirement. So one of the things that they're pointing out in this brief is that the contempt of Congress argument has been predicated on part of the litigation in this very case in the courts, arguing that that itself comprises contempt because they're not going to Congress and instead going to the courts. Now, personally, I would say two things. First of all, contempt of Congress in this context is unclear. And second of all, going to court to argue against the injunction or asking the court to rule on it is part of the perfectly normal process of how these things are handled. You know, the executive branch has many times denied people going to the legislature, and what they do is they go to court and force the issue. You know, and so this is like typical. So to argue that's obstruction when it's part of the typical process is a bit unusual at the minimum. So that's one of the things they're talking about. But wait, there's more. There's also the brief from the judiciary, the House itself, where they make different arguments than the Department of Justice as to its interests. So let's read on about what the Congress has to say about it. According to Congress, The Judiciary Committee writes, "This case is not moot, first because McGahn was a witness to several of the president's past efforts to undermine investigations into foreign interference in elections, which relate directly to the obstruction of Congress article of impeachment. McGahn's testimony is also relevant to the committee's ongoing investigations into presidential misconduct and consideration of whether to recommend additional articles of impeachment." So anyone who is hoping that the impeachment vote meant that the impeachment is over, I think we were all fools for thinking that, because the House has indicated that they're looking at additional articles of impeachment. So they've impeached the president once, they're going to impeach him again, impeach him a third time. So we're going for multiple impeachments. It's the first president in history who's going to be impeached. So now the betting pool is not on whether the president will be impeached, but how many times will he be impeached? That is the only issue relevant to continue to discuss. So we're going for multiple instances of impeachment. That's super exciting for all. It also means that there's a precedent that's now set that we're just in continuing impeachment inquiries. I once half joked that the Senate would announce any day that their impeachment inquiry into the yet-to-be-determined next Democrat president of the United States would begin any day now. Because why do we need to know who they are in order to impeach them? So maybe now impeachment will just become another thing that's continuously happening for both Republican and Democrat administrations perpetually, and this has just never stopped. So this is the new hell we're all welcome into. Welcome to your life, I suppose. McGahn's testimony is vital to the House ongoing impeachment proceedings in several respects. McGahn's testimony would inform the House's decision-making regarding the presentation of articles and evidence in the Senate. Personally, I would think that you would already know that by the time you voted on the articles. You'd already know the case that you're going to be presenting, and you're like, we're ready to present. You're like, no, but we're not ready to present. It's like, but why do you vote on them then? And the whole thing is so weird. It's like a prosecutor going to court and saying, I have this indictment, but I'm not ready because the FBI is still investigating the case. It's like, what are you talking about? The investigation's over. We're ready to go forward. What is this? As the committee has explained, although the second article of impeachment focuses on President Trump's categorical and indiscriminate obstruction of the House's impeachment inquiry, the consistency of this obstruction with broader patterns of misconduct is relevant and striking. The pattern includes the fact the president sought to curtail the special counsel's investigation in a manner exempting his own prior conduct and instructed the White House counsel to create a false record and make false public statements. The committee thus continues to have an urgent need for McGahn's testimony to further support the misconduct described in the second article. For example, if McGahn confirms to the committee the president ordered him to fire special counsel Mueller, an event President Trump has publicly disputed and then tried to cover up, that testimony would constitute powerful evidence of a pattern of obstructive behavior described in the second article. If McGahn's testimony produces new evidence supporting the conclusion President Trump committed impeachable offenses that are not covered by the articles approved by the House, the committee will proceed accordingly, including, if necessary, by considering whether to recommend new articles of impeachment.
The party never ends, the game begins again. The party never ends, the game begins again. The party never ends, the game begins again. The party never ends, the game begins again.
So that is the end of our coverage of the briefs in the ongoing case to be argued January 3rd in the District Court of this Court of Appeals for the District Court of Columbia in the case of Committee of Judiciary versus Don McGahn. In this case, we learn that Don McGahn is still being asked to testify. The DOJ says it's relevant to some issues, but not really relevant to others. And the House says, no, actually, we want to impeach the president many, many times. Our impeachment isn't over. We want to do more. We want all the impeachments. So I think we can look forward to many, many more impeachments to come. And that's just the end of this story.